vet very salacious allegations, and in doing so, the NFL hired outside counsel. They had their counsel looking at it. They reviewed over 650,000 emails. Now, during the course of that investigation, emails came to light regarding Jon Gruden, and they spanned nearly a decade, from 2010 to 2018. Many of them were at a time period when he was an analyst on Monday Night Football. And Lori, everyone from the football world, the sports world, to the water cooler at the office are scratching their heads and going, Jon Gruden, what were you thinking?
Well, this is so different from the public persona that he exemplified every day. And here's the thing. He sent these emails from his personal account, but they were sent to a friend's work email. So let's talk about that. Let's talk about, well, the comments and what they constitute legally, i.e., if he hadn't resigned, could he be taken to court over some of these?
Well, and let's talk generally, because these emails are so salacious, it's even hard to paraphrase some of the emails.
We can't say what they are.
They are homophobic, they are misogynistic, they are racially motivated, they are emails that contain pictures of Washington Redskins cheerleaders in various states of undress sent by Snyder, the owner of the franchise. And the emails were also very personal. It described people of ethnic origin in very disparaging, derogatory
despicable terms.
They were basically despicable.
Yeah.
And so the speculation is, why did Jon Gruden resign in the wake of a 10-year, $100 million employment contract? Because there was a moral turpitude clause in his employment agreement. That's the speculation. But Lori, here's the thing on free speech. As an individual, you can say things that are despicable. You can say things that are disparaging. But once you put on the hat or get into the role of an employer or a manager of
power
employees,
broker.
Power broker, you got to be an employee and an employer.
But
that's true. But he still has First Amendment rights. There's a case the Supreme Court that came out last term where a cheerleader in Pennsylvania was upset with her cheerleading coach and had some emails that said F my coach, F the school, F cheerleading.
Right.
It took, I think, 6 years to wind its way to the Supreme Court, and they said you have a First Amendment right. Justice Potter Stewart said the famous words, you have a First Amendment right, but you can't yell fire in a crowded theater. In this case, everybody now is running as fast as they can from Jon Gruden, because what you have is a decision maker. You have a personality, the face of Monday Night Football. You have someone that is making employment decisions about women, about people, minorities, about people that have gender preferences that are different than other individuals. And again, the fact that he would, one, think these things is despicable, but put them in writing in an email is just baffling. But legally,
it really is.
And let's talk about the Dan Snyder, owner of the Redskins, sexual harassment issue.
Right.
If the allegations are true, that he was sending individuals like Jon Gruden pictures of employees, cheerleaders in states of undress. There are two kinds of sexual harassment. Quid pro quo, which basically says you will get promoted, you will keep your job
if you do this.
If you do X, Y, and Z. Or there is a hostile work environment that basically means the environment is such that a reasonable person would find the environment, and it can be touching, it can be comments, it can be posting emails, offensive, and it has to be unwelcomed. So, if you read those emails from Jon Gruden, clearly if you were in a lawsuit, you don't want him to be the person. And think about this. He was complaining that the NFL franchises were drafting players that were gay.
Yeah.
And he used very
And he put it in terrible terms.
Yeah. So imagine if you have to justify giving somebody playing time or not giving somebody playing time as coach of the Raiders.
Let's talk about this, for people watching, and please share any questions you have as well. And I hope I can have access to those. We're looking at them now. I don't see them, but I see that a lot of you are watching. So go ahead and send any questions you have for Greg about this issue. But what does this say to people like you and me at work, sending emails to whomever? What do we need to learn from this? Lessons learned.
What we need to learn is our founding fathers gave us certain fundamental constitutional rights, and one of those is our First Amendment right. And Lori Tucker, as a private citizen, Greg Isaacs, as a private citizen, has a lot of latitude. When you are in your capacity as an employee or a personality for WATE, when I'm acting as an officer of the court, it's a different dynamic. But when you're an employer-employee, you trigger a whole panoply of state and federal laws that protect people from discrimination based on age, race, sexual orientation, gender, all of those things. And it's almost as if Jon Gruden went to the water cooler and read all of the things that you should not do.
And did them.
And did every single one. It's like George Carlin saying the skit about the 7 words you can't say on the air. And his whole skit was saying what the FCC won't let you say. Jon Gruden violated every misogynistic gender prohibition. People that have LGBTQ issues, people based on their ethnicity being in leadership of the NFL, employees sending pictures, cheerleaders, Dan Snyder. So it's crazy. So you could never, if you were the lawyers or you're an owner, put Jon Gruden in a decision-making individual as a supervisor of employees, ever. He's done. You will never see Jon Gruden supervise somebody in the sports world as a manager, supervisor. You will never see him on TV as a personality because it is salacious. And it's actually one where I predict, even though Jon Gruden as a but of course you also cross the line when you become the legal analyst for Monday Night Football. It's hard to take your personality hat off and put your private citizen hat on, but I don't see how you can ever put him out front because you immediately
these things
and everything, like criticizing an African American player for taking the knee during the national anthem. Whether you agree with it or not, you were the coach of the Raiders. So it has created a firestorm, and what it's done, out of these 650,000 emails, Lori, it has put the NFL in a hot seat. Roger Goodell, the head of the NFL, who was not above being criticized by Jon Gruden.
Right, he was mentioned as well.
He was mentioned as well, is facing calls to release all 650,000 emails. So think about this. If you are somebody that's an employee of the NFL, if you're an employee of one of the franchises, and you hire a smart lawyer, and you say this is a pattern and practice that has been ongoing and covered up, let me tell you the first thing I'd do. I would send a check and I would issue a subpoena, Ducey's Tecum, for all 650,000 emails. And so, today it's Jon Gruden. Who is it tomorrow? So there are a lot of people.
This could open up a lot.
It's going to open up Pandora's box. And this culture that tended, it was worse than a high school locker room. These are professionals getting paid millions and millions of dollars. We're just not talking millions, tens and hundreds and millions of dollars. And they are disparaged. Not anymore. So I'm going to be interested to see legally what the fallout is, because I will tell you, I bet there's a lot of employees that feel they were discriminated against, whether it's hostile work environment, sexual harassment, or quid pro quo, that you're going to see litigating this matter, and they are going to want to see the emails.
All right. We're going to keep you posted on this, and let's talk about this more at 5:30, shall we?
Sounds like a deal.
Thanks so much for being with us.